How are U.S. letters testamentary recognized internationally? Imagine you are managing a loved one's estate that includes property or assets in another country. You might wonder how your U.S. court-issued letters testamentary will be accepted abroad. These documents are official court orders that give you the authority to handle the estate in the United States. But when it comes to international recognition, things get a bit more detailed. First, it is important to know that letters testamentary are not automatically accepted outside the United States. Each country has its own rules about recognizing foreign legal documents. To make sure your letters testamentary are accepted, you will usually need to authenticate or legalize them. This process often involves getting an apostille, which is a special certification issued by the Secretary of State in the state where the probate took place. The apostille confirms that the court order is genuine and valid under international standards. Most countries that are part of the Hague Apostille Convention accept this certification without much trouble. However, if the country is not part of this treaty, you might need to go through additional steps like consular legalization. This involves having the document certified by the foreign embassy or consulate of the country where recognition is needed. Another key step is translation. If the foreign country's official language is not English, the letters testamentary and related probate documents must be translated by a certified translator. The translation may need to be notarized or certified by a foreign court or notary to ensure accuracy. Once authenticated and translated, you may need to submit these documents to the local probate or court authorities in the foreign country. They will review the documents and issue a local recognition or a similar legal document that confirms your authority. This process can take several weeks or even months, depending on the country's procedures. Foreign banks and property registries usually requiring these recognized documents before releasing assets or transferring property. Without proper recognition, you might face delays or even denial of access to estate assets abroad. In some countries, recognition procedures are straightforward, especially if they are part of the Hague Apostille Convention. Others may requiring additional steps like consular legalization or specific forms. For example, transferring inheritance assets from the United States to Mexico involves obtaining an apostille and providing certified Spanish translations to meet Mexican legal requirements. Understanding these steps is especially important if the estate involves international assets or beneficiaries living abroad. Properly authenticated letters testamentary help ensure the estate administration goes smoothly, avoiding unnecessary delays or complications. In summary, U.S. letters testamentary are recognized internationally only after they are authenticated through an apostille or other legal certification, translated if necessary, and processed according to the foreign country's legal procedures. Preparing these documents correctly is key to managing estate matters across borders efficiently.